And questions will be taken at the end of the presentation. You can go ahead and submit your questions through chat for Naomi Dewey, and we'll be happy to answer those questions at the end of her presentation. So a little bit about Naomi. Naomi studied journalism and earned her BA from the University of Sheffield, and earned her Juris Doctor in 2007. With a background in litigation, Naomi represents clients ranging from government entities to nonprofits, private families, serial entrepreneurs, and business owners. She believes that by gaining a deep understanding of each client's mission and goals, legal services can be delivered more effectively and efficiently. Understanding what clients want and need will always come first. Naomi has a number of awards. Some of her awards include the Pacific Coast Business Times Top 50 Women in Business and Who's Who in Professional Services, Super Lawyers Rising Star, co-chair, Women's Economic Ventures, League of Extraordinary Women, first vice president of California. Actually, she has now recently been named the president of the California Women's Lawyers, the only statewide bar association for women in California. So congratulations to Naomi on that. And I am so pleased to share with you that Naomi and Trusted Legal are one of our corporate sponsors of NAWBO Santa Barbara. So Naomi, thank you so much for being here today and for presenting your information. I know that we were really excited to have you and to share all the information you have to share with us.
Thank you, Ali. It's exciting to be here. I know it's a small group and I really appreciate you making time on a Thursday afternoon. So I've got a lot to talk about today. And like Ali said, please ask questions in the chat. I really want to make this as interactive as possible. And I'm going to also screen share a PowerPoint. So if there are messages in the chat that I can't see for any reason, someone can try to flag me down and let me know. So let me see if this works. So I've actually worked with NAWBO and been involved in NAWBO for a number of years, since before I was a business owner. And I want to make sure, do you see my PowerPoint, everybody? Okay, I went through a whole PowerPoint with the AIA, and at the end someone said they hadn't been able to see my PowerPoint, and I just thought, okay, that's not good. So I want to be sure that you can all see it. Here we go. You see, I'm sharing you the wrong thing. So I'm going to talk about how, as business owners and as women, we can take the new employment laws that come out at the end of every year, beginning of every new year, and kind of turn them upside down to work them to our advantage. There's a lot of programs around this time of year about new laws that have been passed and how they're going to have somewhat of a negative impact on businesses. My attitude for my clients is, if you stay on top of the new employment laws, you can use that to your advantage. They shouldn't be a threat and they shouldn't be something you're afraid of. And this statistic is huge for me. It's something that I've really followed through my career. I heard it first at a NAWBO event. I think it was, I can even remember where I was in the room. It was at the Fest Park years ago. That the biggest obstacle to the growth of women-owned businesses is fear of hiring. And that was just one of those profound moments for me when I thought, you know, that so many of us are afraid of the law, and they're afraid of employment law in particular, because it can be so tangled and unmanageable. There's a lot going on. But if you don't hire people, you won't grow, right? You're only going to be limited. You're going to be limited every day by the number of hours in the day. So I really want to try to make it easy for clients to hire people and to grow, because we all benefit from that. So one of the big things that we look at with this is that hiring does cost money. The average cost, and I want to be realistic about that, right? The women that don't hire, it's not just fear of the law, it's money. Average cost of onboarding a new employee is about $4,000. That's across the country. And that doesn't include some of the things like background checks. That's your time, the time spent away from working on your business, setting up all the payroll and so on. But the average cost of terminating an employee gets really high. not only is it a disruption to your business, but you have things like unemployment contributions, severance payments, legal fees. I always like to tell clients that you need to be slow to hire, you need to take your time to hire someone, and you need to be quick to fire if it's not working out. Even right now, keeping employees happy is really, really important. We've gone into a time, unfortunately, where there is pretty high unemployment, even in Santa Barbara County. That doesn't mean it's easy to find the right employees. So complying with some of these laws that we'll talk about is actually going to benefit you because it's going to make you more attractive as an employer. You know, again, if one of you goes away and feels confident to hire a new person after today, I feel like it's a win for me and it's a win for all of us. Anytime that you find yourself panicking about employment law issues, just tell yourself you've got this. Don't panic. There's a lot of good resources out there if you can't afford a lawyer. And I'm going to jump right into the new laws that we're going to see for 2021. So the first one we see that's coming up is what we call kin care leave. And if you're an employee and not a business owner, this is also going to impact you. Kin care leave is an extension of the labor code that allows your employees to use their sick time to care for loved ones, children, immediate relatives. And the reason that I like this new law is that when we're dealing with employees and employee health, there's a lot of risk. And I think women, I'm going to be a little sexist, I think women tend to care more for their employees. And we're more likely to, employee will say, I can't come in, I'm sick. The reflex is, oh my gosh, what's going on? And you very quickly as an employer get into dangerous ground with that because you're asking your employees about their health conditions. In this sense, you're also then under the old law, if an employee was not sick, they would tell you, I need to take time off to care for a child or for my mom. That's gone away. So you, if you are granting sick leave to your employees, know that the employee can choose to designate it for looking after sick kids or whatever else qualifies, but you do not have to seek out that information. It's up to the employee whether or not they want to tell you how they're using that time. So this is one of those really, I think, good news pieces of law. You know, a couple of things. Employees that get access to paid leave are less likely to come to work when they're sick. And research shows that a good paid leave policy is going to decrease your turnover. So a lot of times I hear lawyers kind of put the fear into their clients. My gosh, mandatory sick leave is coming. It's super complicated. You've got to comply with it. The reality is, once you can leverage that law to grow your business, it's going to make you more attractive as an employer, and it's going to help protect your employees from getting sick. So it's not all bad news. This is kind of what I would call it in the end, which is that you do have to have some policies and procedures in place to track how people are using their leave. So it's not all good news, but overall, I think this new kin care is going to be a win for women-owned businesses. The next one I have that's coming is really going to have a huge impact, and it relates to unpaid leave for employees who are caring for themselves, a child, grandparent, and so on, a close family relative. It also allows for up to 12 weeks of unpaid leave to bond with a new child. This law was for people with over 20 employees. It now comes to employers with 5 employees or more. So it's going to be a huge, huge change throughout California. I think this is probably one of the biggest impacts that we're going to see. It also extends out to employees who are caring for an employee or immediate family member if they're called to active duty military service. The good news, I think, for us as women business owners is that most caregivers are women, and so this does protect women in the workplace. The bad news here is that there are now 3 or 4 different kinds of unpaid family leave that your employees might be entitled to. And some of those leaves stack on top of each other, like pregnancy disability leave with bonding. And so if anyone is in the business is covered by this 5 or more rule, we have some really great charts that we can share, which allow you to track when you qualify and just, you know, what type of leave an employee might be entitled to. And remember, this is unpaid leave, so it's not costing you anything as an employer to grant someone this leave, so long as you can find someone qualified to fill in when the employee's gone. And it is a protected leave, which means you can't fire someone when they take that time off to bond with their baby. It's also a kind of a new thing is that if you have 2 parents in your workplace, they can both take this 12-week leave. So it's not just a mom or a dad that has to choose which one takes the leave. You could be faced as a business owner with having 2 employees out simultaneously to bond with that new child, which then does start to have an impact. So it starts January 1st. We're all ready for it, but again, there's just such a web of these laws now. The next one I want to talk about is the Families First Act. And I did a lot of presentations at the beginning of the shutdown in March when we thought that this is hilarious, but we thought it might last as long as, you know, maybe even 3 months. We were going to be shut down. So this was put into effect in late March, early April. It's a federal rule. And it's also, you know, Anika like this, it also carries a tax credit. And it's the Families First Act, which right now is set to expire on December 31st, because as you've probably heard, there's a complete standstill in Congress and in the Senate of any sort of ability to get new COVID relief packages in place. I had a question from another client, from a client the other day who said, what happens if I have an employee that goes out on this leave in the last week of December? Do I stop paying them on December 31st, 2020? And right now there's no guidance in the law because we're waiting to see what gets passed. This law requires employers that have under 500 employees, employees with over 500 employees are exempt, to pay 2 weeks of paid sick leave to an employee who's unable to work because they're quarantined or they have COVID-19 symptoms or a diagnosis. So they get full pay for that time period. And there are some ways to claim exemption from that, but what we're seeing is that actually, because there are tax credits if you do pay that leave, it's pretty hard to get exempted from that. And then it also has 2 weeks of paid sick leave at 2/3 of employees' regular pay if their school is closed or their daycare is closed. What's cut off from this slide is that 2/3 pay will extend out to 12 weeks. So an employee could have a total of 12 weeks at 2/3 of pay if their school is closed. And when this first came out, employers were really kind of terrified about what it would look like. My understanding is that there are some tax credits available if you do pay that leave. Again, it's just going to go away, right? The way that I think this benefits businesses is that I've seen a lot of businesses use these when they're just not sure how to react to an employee that might have COVID-19 symptoms. I've also seen employees, frankly, try to abuse this, but it's capped at 2 weeks, right? So you only get 2 weeks paid time off. If you travel and then you need to quarantine and then you travel again and you need to quarantine, you're going to run out of the leave. So it's a neat thing. I've included it here because especially because of what's going on in the country right now, I suspect we'll see something extending this out. Okay, another new employment law that actually came into effect over the summer is fast-track disability payments. And this is also really helping a lot of my clients. A lot of my clients are women business owners. The concern from clients is if I have an employee that's diagnosed with COVID, or if I have an employee that's quarantining, and they can't come to work and they don't have sick leave, and I can't afford to pay the family's first federal leave. What do I do? And what California did is they put in place fast track disability payments for employees, so that an employee who does become sick or is quarantined can then get the SDI benefits. The employee applies for them directly from the state, and it is 60 to 70% of their pay. It does cap out. It has helped a lot of my clients who were feeling bad about how their employees would manage if they didn't have paid sick leave, to just shift some of that responsibility onto government benefits. And so it was, you know, it's been a nice thing to have as a tool in your toolkit as an employer. I do have to say what's a little bit funky is that the whole state process for disability benefits is not set up to process these. So I've had issues where employees have seen their claims accepted weeks after they return to work. And everything from a lot of these state agencies is coming through in the wrong order. You know, you might see an unemployment claim, for example, denied before you know that the claim has been made. And SDI, state disability insurance, is really covered by that, unfortunately. So I have a question. Can I answer that publicly? Okay, so the question is, if you have an employee who qualifies for one of these leaves, but you as the employer do not realize they qualify until after the fact, what are the ramifications? That is a really great question. It does depend on it depends on what type of leave, first of all, right? So leave like SDI that's obtained from the government, it's the employee's responsibility to claim that. The FFRCA is a federal rule, right? So it has federal penalties. It is not a well-developed law. So I'm not aware of any employers yet who have been penalized for not following those rules. There are some ways to claim exemption from the federal rule by saying you simply can't afford to pay the cost. And the law has developed with a set of regulations that says, what do you mean you can't afford to pay it? You get a tax credit, right? So there are some ways that people can get out of that. So it really does depend on the benefit, what the ramifications are. For state benefits, if it's an employer-paid benefit, especially with the leaves that we talked about for kin care and so on, then there are some pretty significant penalties, including the fact that you could be subject to a retaliation or discrimination claim by not granting someone with a child a type of leave, for example. So it really does depend on the law. I'll try to do a better job, though, of explaining the penalties as I go through. So a question that came up a lot, more than I expected this year, was how do I handle employees that don't qualify for state or federal benefits? And that's a nice way of saying employees that are undocumented. And California has a lot of legal protections for undocumented employees. You really can't discriminate against someone who is undocumented. So what I've been advising clients is treat that employee as if they were documented. If for any reason, because if you're on notice that they're undocumented, you're in a trap under the law. Federal law, you are not legally permitted to hire them or to continue to employ them. State law, you're not allowed to discriminate against them by terminating their employment. It gets very, very complicated. So if you have employees that are undocumented for any reason, treat them as you would a documented employee. Don't make that guess if you're not sure. There are also, there was a time this summer where there were a lot of funds set up locally to try to pay the equivalent of unemployment or disability to undocumented employees. It's not really a legal thing, but it's important to know in California that undocumented employees have a lot of the same rights as documented employees, and sometimes more. So just tread carefully around that if you're talking to your employees about benefits. Okay. So we also saw this year a bunch of new wage and hour laws. And when I say wage and hour laws, I'm talking about the laws that govern how you compensate someone, what entitlement they have to meal breaks, rest periods, what are their basic rights around being in the workplace. And one of the things we've seen over the last few years is a real push against arbitration agreements. And an arbitration agreement that you would use in the workplace is essentially a contract you enter into with your employee that allows you to agree with that employee that instead of suing you if anything goes wrong, they'll bring a private action in arbitration against you. It keeps things out of the courts, and a lot of times the Labor Commissioner in particular has been very frustrated about that because it sidesteps the Labor Commissioner process. So what we're seeing in Senate Bill 1384, which also comes into effect in January, is that in response to all of the litigation around arbitration agreements, employees can now have a Labor Commissioner represent them in the arbitration process. A lot of times clients will pay us to write arbitration agreements, particularly because they don't want to go to the Labor Commission, because the idea is the Labor Commission is not friendly to employers. It's designed to protect the rights of employees. There are some criteria around this. I really kind of look to find some good news in this because, you know, I'm trying to find the positive in all of these new laws. I think it could lead to having more arbitration agreements being upheld, because one of the criticisms of arbitration agreements is that it's expensive. And for employees without attorneys, it can be difficult to navigate a case in front of a private judge. The downside of this is that arbitration agreements aren't guaranteed. So for clients that work with us, what we say is, you know, we will write you an arbitration agreement. You know that it is not mandatory, it's voluntary. You can't force your employee to sign it. And at any one time, depending on where the case law is, there's probably a 50%, 75% chance it would be enforceable, but it may just not be, it may not be upheld in a court, and you'll find yourself in front of the Labor Commission anyway. And the other thing to remember is the local Labor Commission, I mean, there's really only one in Santa Barbara, and I think she's great. She does a good job, and I respect her as a woman and a human being, but she's not on the side of employers. She's specifically there to enforce the rights of employees and does a really good job doing it. If you are an employer and you find yourself called to the Labor Commission, tread very, very carefully, because it's not going to be a fun time. Okay, another new wage and hour law we're seeing is Assembly Bill 1947, and that extends the time that an employee has to file a Labor Commissioner complaint out to a year. It was 6 months. And it allows employees to recover attorney fees. So again, kind of hard to find a good side to this, but I'm trying to make sure that we can kind of think positively about these. I think a really good thing for business owners is it's still less time than that employee has to file a civil lawsuit. And the downside is that that employer will get attorney fees, right? The employee could get attorney fees if they win in the Labor Commission, and it's pretty easy to win in the Labor Commission. I think if you're looking at how to use these rules with the Labor Commissioner in terms of how you run your business, knowing that these are out there, you're just going to assume the Labor Commissioner is like a pothole in the road, right? And if you're driving in the right lane, you're not going to hit the pothole. Sometimes you hit it anyway. And it's maybe not the biggest pothole in the road. It's maybe not the most expensive. It's quicker than a claim in the Superior Court. Sometimes it can be easier for employers to represent themselves. You less frequently see attorneys there, but the odds are not in your favor. So it's just one of those facts of life we have. I don't want that to put anyone off hiring, because remember, you want to be in the 10% of businesses that have employees. My dog has just broken into the room. So okay, so this is almost a whole presentation in itself, but a lot of you have probably heard of the ABC test or Dynamex, which is the independent contractor rules that we saw in the last couple of years. What we're seeing now is that the law is really evolving to clarify exemptions, who's exempt from that rule, because we saw that there were a lot of things that just didn't make sense. One of the things that I like in here is that there is now some exemptions for landscape architects. That's great. Artists, musicians, performance artists, freelance writers, photographers, people really that do one-off special tasks and exercise creative, they exercise creativity in the way that they do their job, are more likely to be found to be independent contractors under the way that the law is evolving. What is unfortunate about these new laws, the AB 2257, is that a lot of questions I get from small women-owned businesses relate to business contracting, right? I am a sole practitioner and I want to get someone to come in and work as a contract, a contract personal assistant for 10 hours a week, or I want them to do my social media. They're providing a business service to you, and you don't want to have to pay them as an employee because it can be expensive and you're worried about hitting the labor commission, a pothole in the road, and all those things. Business to business contracting has actually gone back to being more complicated. The bad thing about AB5 and Dynamex is that it was, it assumed that, the law assumes that everyone that provides the service for money is an employee. But it's straightforward, right? At least we know where we are with that. With business to business contracting, there's now a 12-factor test that you need to go through to decide whether the contract that you're entering into with another business to provide services to you is an independent contractor or an employee. And I see most of the AB5 issues I see would fall under this business to business contracting rule. I haven't included the test here, but I think the most important thing for you to ask yourself as a business owner is, how much control do I want to have over the way the person does the job? And essentially, the more control you have, the more likely they are to be an employee. So AB5 and Dynamex have 3 tests to get to that conclusion. Borello has 12. And so for the average person on the street, it's really not much simpler to understand. And there's extra steps that you could get wrong. So the real good news, though, is that the law is getting cleaned up, and especially for people that are in the creative professions, there's a lot more clarity. I think ultimately it would be really neat if we had a list, right? And you're either on the list or you're not on the list, and the law is definitely moving that way. It's just not there yet. It's still a minefield, and you still need to work under the assumption that the person is an employee and you would have to prove otherwise. And then if you drive an Uber, you're fine, because you're not an employee and you never will be, because Uber has so much money that they got a proposition passed all for themselves. Another thing we're seeing this year is pay data reporting. And this is something which has been really pushed by some very vocal people in the Senate in California, particularly to push back against unequal pay for women. So we've all heard the statistics about unequal pay day and how women make 78 cents on the dollar for every dollar, for men, and all of those different statistics. This only covers employers with 100 or more employees, but I thought it was really important because often what we see as employers is that the law starts with the big employers, and then it works down to the small employers, just like we saw with the parental leave. And I just saw another couple of questions pop up, so I'll answer them in a moment. So on this pay data reporting, right now, anyone with over 100 employees have to report pay band categories, and they have to report the number of employees by race, ethnicity, and gender. And what that does is it moves towards a system where we're going to have more clarity around pay data and equality. So for women, it's fantastic. I think for business owners that are worried about that, they've got to look at their internal systems. I know that I got a message from my payroll provider that if I qualified, which I don't, thank goodness, because that would be too many employees, they have automated reports, right? So it's one of those things where you could really allow this to paralyze you, and you'd think, I don't want to hire my 100 employees, because if I've only got 99, I won't have to do this. If you get on top of this and you're in that position, it shouldn't hold you back. And I do see women that are worried about hiring extra employees because it moves them into another band of responsibility. I really think that's not your attitude. Your attitude is, how can I grow my business? Okay, here's the questions. What protections do employees have when they're high risk and must work from home during COVID? If the employer decides to lay off, are they protected from losing their jobs? So that's a couple of questions in one. If an employee is laid off because of a health condition, they may have a disability claim. So that's one thing to think about. We're also talking in a minute about some of the workers' comp rules around that. And then what I've been saying to employers is this: if you're going to do layoffs, and unfortunately, I think we're going to see another wave of layoffs in Santa Barbara County coming really soon, because the recent move back to purple tier has had a really, really big impact on employers. If you're going to lay off employees, have objective criteria that are related not to the individual but to the position. So as an example, I have a client here with about 50 employees. They've gone through every position from receptionist through to CEO, and they've made a determination as to whether or not that position is suitable from work from home. So then if they lay off employees, it's based on financial needs, not on anyone's individual health status. And working with them on that, we did it so that it was very important that they didn't have in mind, well, you know, that receptionist has this health condition, so we can't have that person coming in. That inquiry comes separately. So the first inquiry is the position something that can be done from home, right? And if it can be done from home, you don't have to get into the question about high risk. Then if a position is designated as a position that can only be done in the workplace, you go through the process of deciding whether that's a disability that you can accommodate. It's really a minefield, especially for those of us that have older adults or children, vulnerable people that we're around. But the most important thing is those decisions have to be made in a way that is, first of all, objective and not related to any individual employee. Otherwise, you run the risk of a disability claim. The other question is, do I consult with clients to help identify whether independent contractors are employees? Yeah, it's probably one of the biggest questions we have, especially when we work with newer business owners. I think that's one of the biggest things that comes up for people as they're looking to grow, is you know that you need help to do your job, but the cost of finding an employee, onboarding an employee, how do you put that employee into your cash flow plan can be really daunting for business owners, and a lot of people hesitate, and they decide that it would be cheaper to bring in an independent contractor rather than hire that person as an employee. I think for most positions, that's a huge mistake. If anything goes wrong, remember the key thing about independent contractors is control, first of all. So you really need control in those early stages when you're growing your business. And the other thing is that if anything happens to that individual, the law is going to assume they're an employee. So just because you're paying them as an independent contractor doesn't mean you're protected from those types of claims. It can get incredibly complicated depending on what the tasks are that you need. Oftentimes for new businesses, like I said, it's something like, office help or marketing or an extra pair of hands. On a different note, outside of employment law, the other thing that I see often, and I also have to untangle often for clients, is when they want to grow their business and they can't afford to pay someone, so they bring someone in as a business partner. If you come work for me for free, I'll give you a share of my business. And I mean, that very rarely works, because what is the business, right? How do you define that? Did you put paperwork in place? Or did you sell them stock? Did they pay you for the stock? Is it a taxable event? So that scarcity mentality is what I really try to work with clients to get around, because the decisions we make for our businesses from a place of scarcity almost always come back to bite us later. It's just a sad reality, I think. Violations. This is a new thing, and again, it's come out in part from, it's kind of a side effect for the Me Too movement, but it expands it out into an idea of calling out bad employers. I think that women-owned businesses that follow the law will really benefit from this, because we're not going to get caught doing anything foolish, right? When you file your annual statement or your biannual statement of information for your business, if you're an LLC or a corporation, you now will have to report starting 2022 whether you have a judgment outstanding to the Department of Labor Standards Enforcement, or you've got a court judgment against you for violating a wage order or part of the labor code. That means that if I'm an employee and I want to go onto the Secretary of State websites to do due diligence on my new employer, I can kind of see what kind of employer they are, right? And again, when I'm talking about using these laws to grow your business, that's a great example, because if we start naming and shaming people that aren't following the law, then it's going to make good businesses more attractive to employees. It also means, and this is important if you're involved in an area where we're buying or selling businesses, that if you can't just get out of that liability by selling your business to another entity, or by selling or by handing over the reins to a new owner. It stays with that entity. I don't mean to kind of rub my hands with glee, because at some point this is going to happen to one of my clients, but it's just one of those things that I think we can work around. So let's talk about COVID laws. This is really evolving rapidly. And I was looking at, we have a mailing list that we send out to clients, and I was looking at the click-through rates the other day, and the most read things we put out around COVID, it reminded me that I need to put some more things out. The law in this area, as you know, is struggling to catch up with the science. It's been kind of a wild ride for lawyers and business owners, and let's face it, all of us. So new employment laws, let's start with these. And the biggest issue is workers' comp. Effective immediately when Senate Bill 1159 was passed, there is a presumption that, and this goes a bit to the question about high-risk employees and who works for home or not, right? Employees that are diagnosed with COVID when they're working outside the home have a presumption that they caught the virus during the course and scope of their employment. So Anika, I see you in your office. Hi, right? If you were to go get tested for COVID and you got sick, your employer would have 30 days to prove that you didn't catch it in the office, right? So this has really been, I would say, had a huge, it's been kind of scary for employers and the insurance industry. It's had a huge impact. It's not insurmountable. What it means is you have to put the policies and procedures in place to be able to prove that you ran your workplace according to the public health guidelines, right? So, for example, in Santa Barbara County, within your workplace, you have to have a physical manual with all your policies and procedures in the workplace that's available for an employee to view. That's one of the ways that you could help rebut the presumption that the employee got sick at work. You have to show that you're maintaining those protocols. You have a duty to pay for any safety equipment the employer needs to keep them safe. So if your employee needs PPE at work, like a mask or gloves or hand sanitizer, any of those things, as an employee, you're responsible for paying for that. So if you can show you're doing all those things right, you have a chance of rebutting that presumption. The good news about that is that when we went into COVID, under the law, as an employer, you were not allowed to ask an employee if they were sick, and you were not allowed to ask an employee questions about their health because you ran the risk of discriminating against them based on their potential disability. Those laws have been suspended. Right now, the Americans with Disability Act and the Equal Opportunities Employment Commission and all those agencies have said, we are not going to enforce rules about health reporting for employers. So right now you can say to an employee, my gosh, you're coughing, are you sick, right? You couldn't say that in early March. So you can ask those questions. The other thing is that you can require a temperature when you come into the workplace. When COVID first hit, that was considered to be a medical procedure that employees needed to consent to. So a lot of the rules around making sure that people don't come to work sick have been suspended. The bad news is the insurance industry is freaking out about this, and if you pay workers' comp, it will be a problem. So another question, can you require employees to work remotely for 2 weeks if you become aware they've traveled and been exposed to a large number of people? It's a really specific question, and I know this person's employer. So just so you know, I can give information, but not legal advice. Yes, you can require employees to work remotely if they have traveled and exposed themselves. And so remember earlier I was talking about that FFRCA Families First leave. That's where I've had employees. I have an employee in LA who runs a manufacturing facility, and they had a bunch of employees that went out of town on a trip. And so all those employees used their 2 weeks full pay quarantine FFRCA leave because they decided to go on vacation together, right? So they were actually off work unpaid. The employer could have required them to work remotely for sure, because you have a legal duty to protect the employees in your workplace from COVID, right? And so having a policy in place, making sure that it's objective, making sure that it is applied fairly, so you're not signaling people out, is really important, right? You get into a real danger, you know, in Santa Barbara County, for example. One of the really most shocking things that it has laid bare is just the systemic racism and the fact that most of the people in Santa Barbara County who have had COVID are brown, right? It's something like, I haven't looked at the statistics recently, but it was really high. It was close to 70%. So for example, if you required employees that traveled who are Latino to work from home for 2 weeks, but not Anglo employees, that's a problem. So you need to make sure that you have the policy and you apply it fairly, especially because we are getting into but you know, we're kind of getting into a lot of demographics that people are using when they make decisions about safety, and that exposes you as an employer to risk. You've got to make sure that your policies are objective and fairly. I know that for all of you, you're fair, but I see some people that struggle with that. Another thing to do is you can ask employees to limit social travel, but you can't force them to do that. And if employees are not able to work remotely because their position, remember, you've defined the position as either suitable for remote work or not, and they choose to travel and they've used their family first leave, then they're going to be out of pocket for a couple of weeks because they've had some elective travel. Travel for work is really complicated. That's a whole other presentation. So another new employment law for COVID, Assembly Bill 685, which is also already in effect. If an employer learns of an employee exposure or positive tests, you have 24 hours to provide written notice to all your employees and any subcontractors who are on the premises with the employee that they may have been exposed. This is any size. This happens if you only have one employee, and we'll talk a little bit about that in a moment. You have to provide employees with information regarding benefits they may be entitled to if they miss work. That's where your state disability insurance or the paid time off comes into effect. And you have to notify employees about any disinfection or safety plan that you will use. And this, I think, is, by the way, where the science is way ahead of the law, because I think the science right now is saying that remember when this started, we were all frantically Cloroxing everything? And right? And now the science says that may not make any difference at all. But under the law, you have to tell the employees that you're going to frantically Clorox everything. So the law is lagging behind the science a little bit. The good news is, this is designed to prevent the spread of COVID, that there's a set of instructions under the law for you to follow. The question says, what if the employer does not tell the staff an employee tested positive? There are some penalties on that, depending on how many employees you have. If you have more than 5 employees, you have to, there is a question, I think Public Health, the Santa Barbara has this on their website. You have to notify Public Health, and you should do that anyway, even if you just have one case, depending on what your local rules are. If you have over 5 employees, there are some specific rules about outbreaks, what constitutes an outbreak, and it's what constitutes an outbreak based on the percentage of employees that get sick. And really this comes out of those cases we heard about, like the chicken factories and so on, right? And then in those cases, you have to not only notify Public Health and your employees, you also have to notify state and OSHA. So it gets to be pretty serious. And they could come in and shut you down. In terms of the remedy for if the employer, if you haven't told staff that someone is infected, I'm not sure what legal claim you would have as an employee against an employer in that situation. What I would say to you is that the employer also has a legal duty not to identify the employee. And with small workplaces, that's really, really difficult. I had a client up in Lompoc, and the employee with the exposure was in a very visible public-facing desk, right? And when that employee wasn't there and tested positive, she had to notify all the other employees that there had been an exposure in the workplace and that she couldn't identify who the individual was. And everyone was saying, oh, well, it's you know who, right? And she was saying, I can't tell you who it is. The employees got very upset about that, but you still have a legal duty to prevent the medical privacy of the person that gets sick. So even if all your employees know who it is, do not use their name. Just there's actually, I think, a script on the Public Health website about what you should say. Written notice can be a text message or an email. It doesn't have to be anything formal, but you must send it to each employee. I think to the question about what happens if you don't tell employees, I would also go back to those workers' comp rules, right? If you don't tell employees and then they don't get tested or take preventative measures, then, and one of them does get sick, for sure you're going to have a valid workers' comp claim against you. So it's a good thing. Again, what I like about this is there's really clear instructions. Go to Santa Barbara County Public Health, follow the instructions. You will be okay if you do that. Okay, so I'm almost out of time. I threw in some miscellaneous new laws here, but I'm happy to answer questions, or I'll just talk for another few minutes about what I have. I'll give you a little taster. It's not that exciting. I told Ali before we started that I moved everything to the back. Consumer Privacy Act was going to apply to employers this year. It's been moved to 2022. All you need to know is that when you have an employee or a candidate for employment, you need to tell them that you are collecting their personal information and you're going to use it for a certain purpose. In employment, that's pretty self-evident. You know, we accept your resume and your application and we'll use it to consider you as a candidate for employment. But you still have to be ready to comply with that, and that's going to cover employers in 2022. I guess they thought with COVID, no one had the bandwidth to deal with this, so they kicked it over. The other one I have is victim of crime leave. There's a labor code section that provides employment protections and rights off to people who are victims of domestic violence, sexual assault, stalking. And there was some elements in here, I think, that treated women differently than men, because women are the majority of victims of domestic violence, unfortunately. What this law does is it just says that if someone has to take time off work because they're a victim of crime, you go and you follow the instructions in your employee handbook or wherever you have them to make sure you're allowing them the appropriate amount of leave and not discriminating against them. And then I ended with this one because I think this is such a win for NAWBO, and I love this. This is, if you've been active in NAWBO and gone to events, the last NAWBO event, the last actual event I went to before the shutdown was the lunch, the NAWBO lunch in Goleta. And we had from Betsy Berkheimer, who was one of the co-authors of the Women on Boards law that was really promoted by NAWBO. So it's not necessarily for employers, but I wanted to throw it in that rule that requires corporate boards, publicly traded corporations, to have at least one woman on the board of directors by the end of 2019. It's going to be, and I hope my dates are right here, I think it should be 2020 and 2022. The new law is pushing this out to say that corporations, publicly traded corporations, also need to look at diversity and have at least one board member from an underrepresented community by the end of 2021. And so I threw that in there because I love the public policy advocacy work that NAWBO does. And I thought that was just a great win. So I've talked a lot and I've got some questions. I am happy to answer another couple of questions or let you guys go enjoy your Thursday afternoon. If anyone has questions for me specifically, my email address is actually right back at the beginning of the PowerPoint. Let me see if I can get back there and I'll bring it up. It's really simple though. It's naomi@trusted.legal. And I'm always happy. I'm always happy to talk to your people. When I do talk to people, I can't give, like I said, I can't give legal advice. I can answer general questions. I really think that we all win when women are successful as business owners. So I do what I can to kind of help make that work. So that's pretty much all I have. I talked a lot. So
Naomi, thank you so much for presenting. Everything was so informative. I really appreciate you, and everybody on our Novel board appreciates you taking the time out of your busy day to support us in this such informative information. I know we are really challenged with a lot of different things right now, and this is really important to women business owners, especially looking to the future, that are looking to grow and hire employees. And there's so much information that, you know, women business owners need to have. So I truly appreciate you, again, taking the time to present to us. I think you had another question or something. Let's see. Oh, okay. Kim put your email address on the chat for us.
She did, and I got one last question, which I'm happy to close with, Ali, if that's okay. Because
absolutely. Thank you.
It matches up with where I started. The question is more of a comment that I feel as though some small businesses fear the cost of compliance with the laws and then avoid them. I think that's so true. And if we're afraid of having to comply with the law, and we come from that place of scarcity as business owners, we're not going to grow. I think it's a much better thing to look at the new laws and think, okay, how can I use this to benefit me? And sometimes it's really hard, right? Sometimes when it's, you know, an increased cost or an increased tax or something gets more difficult, sometimes it can be hard to find the bright side in that. But if you approach those with the idea of how can I use this to grow my business? How can I make myself more attractive as an employer to recruit better employees? Then I think it's going to benefit you, and it will benefit all of us.
Wonderful. Does anybody have any other questions for Naomi? If not, we will end our session. And thanks again, everybody, for being here. And Naomi, thank you so much for your time.
Thank you, everyone.